Welcome. Today's agenda, what I want to cover is the longevity revolution, which is something that we already know that's going on. Then I'm going to cover the basics of an estate plan, not only for those who do not have an existing estate plan, but also for those of you who are currently our clients or currently have an estate plan. And most important, I want to give you some legal updates that have occurred over the last few years. I will be discussing long-term care protection, which is something so important to all of us as we age, and then identify the other documents that go together with the core document, the trust in an estate plan, and then offer how we can help you. All right, the longevity revolution. It is absolutely well known that we are living longer. When you and I were children, what did we have in the medicine cabinet? Maybe penicillin, Alka-Seltzer, Pepto-Bismol, Carter's little liver pills, castor oil, and that was pretty much it in our medicine cabinet. But as we have evolved in the medical field, it is not unusual to see a magazine cover like you see on the screen that are really promoting the fact that we're going to be living to be 100. And not only will we be living to be 100, but we will be able then to enjoy a lot of these later years of our life. Statistically, we're spending a heck of a lot more time in retirement. After the turn of the century, the year 2000, as you see on the right-hand side of the screen, we're spending probably 20 to 25 or maybe even 30 years in retirement or past the time that we decided to stop working. And so the fact that we're living longer and the fact that we are living, I'll say, a lot of us in retirement are creating some problems. Let me get rid of this thing that's on the screen. One person who definitely is providing the guide and the light for us living longer is William Shatner. We all know him as Captain Kirk. He recently flew on the spacecraft that was really put on by Bezos, the fellow who has Amazon, and he is the oldest man in space at age 90. And look at him. He absolutely has enjoyed it. And this is a testament as to what you can do when you reach old age. Old age is not a determining factor as what you can and cannot do. As we age and we live longer in retirement, there are two major problems that come to mind. Obviously, the first one is if we live longer, we're not working, maybe we're going to be running out of money. And the other one is if we're living longer, the fact that during the last phase of our life, we may be dealing with incapacity issues, that brings to focus the new, I'll call it, the new focus of an estate plan, which is protecting our assets while we are living longer and possibly dealing with issues of incapacity. So talking about running out of money, I'm not going to be spending a lot of time today on running out of money, but I do want to offer something for all of you. We work with a company called Lifestyle Financial, and we are absolutely living in a volatile time. We know that. We have inflation. We have the Ukraine issue, the war, the possibility of a recession. And what Lifestyle Financial is offering is the review of your portfolio to make sure that what you have in place right now is on track. And they are willing to meet with you and provide a second opinion on your current holdings. The company can handle managed accounts. They can provide investment advice. They can talk about annuities, life insurance, long-term care insurance, retirement accounts, and pretty much provide you with advice to give you a second opinion, and it's absolutely free. So this is something that we are offering to all of our clients to take advantage of this opportunity to get a second opinion on the financial issue that you may or may not be facing. But what I'm going to do now is I'm going to concentrate on the estate planning. And one more point on the financial. The old traditional 60-40 mix of stocks and bonds and so forth is not really working any longer. And again, because of COVID, because of the inflation, the geopolitics that we are now experiencing, all of those things now have an impact on the portfolio. And again, we just want to offer the opportunity for you to meet with somebody that can give you the second opinion that you may need. As we get older, it is not hard to figure out that some of those later years may not necessarily be our best years. We may still be alive, but we may be dealing with issues of incapacity, long-term illnesses, maybe falls. And so our health may not be as good as it was when we were 19 and 20, but we're still alive. And therefore, we have to focus on something new when we design the estate plans of the future. The focus of the estate plans for today are primarily focusing on protecting your estate from losses that can occur because of an illness or incapacity. You work hard all your life, and then at the end of your life, something happens, there's a fall, or you're subject to a devastating illness, Alzheimer's. So how do you protect your assets? How do you protect everything that you worked for from these debilitating incapacity issues and related illnesses that can last for years, and the cost of health, which is increasing every year? What do you do? What kind of planning now does your estate plan have to have? It's important that you maintain your estate plan updated with current laws, and I will cover what these current law changes are. For those of you who do not have an estate plan, I want to point out that even though you may not have a will, or even though you may not have a trust, the state of California has, for everybody, an estate plan of their own. The state has developed an estate plan for all of you who are dying intestate or will die intestate. And that plan more than likely will not guarantee that your estate will be transferred the way you want it to be transferred, because the state of California never sat down with you or I and asked us how we want our estate to be distributed. What they've done is they have built an estate plan for everybody. So dying intestate means that you do not have control as to who is going to get your property. The next best thing to dying intestate is to have a will. A will does identify who would get your property. But here's the problem. The fact and the way you choose to transfer your assets at death, either intestate or through a will or through a trust, will determine the settlement or the administration costs that will occur upon your death. When you die with a will or without a plan, like I mentioned before, dying intestate, you have to transfer the property that is controlled by these two plans, will or intestate, through a process called probate. And that is a legal process that may take up to a year or a year and a half. And at the end of the probate process, the court will prepare a court order that will distribute the property to your beneficiaries. A probate procedure is a legal process consisting of state rules, can take up to 24 months. An example, Marilyn Monroe's will, can you believe it took 39 years? I don't expect any of ours to last that long. But the point is that probate takes a long time. The control is with the court, not with you. And all of the information in the court system, everything that you own, who's getting what, all of your debts, all of that becomes public information. On top of that, there are legal fees and court fees. If you look at the chart on the left, the lighter gray, it says gross estate. What that means is that there's no liability subtracted from the value of the property that is going through the court procedure. For example, if you have a home worth $500,000 and you have a mortgage against it of $400,000, the equity that you own is only $100,000, but the fees are based on the gross value, the $500,000. And therefore the fee on a $500,000 home, even with a $400,000 mortgage, is going to generate $13,000 to the lawyer, and the executor receives the same amount of fees as the attorney. So right there, you're up to $26,000, and then there are court costs. So quite frankly, transferring just a single home to a child, for example, could cost you up to $30,000 and about a year in court. This is something that needs to be avoided. It can definitely be avoided. And the way that it can be avoided is simply by having a different type of an estate plan. And that type of an estate plan is the one that is centered around a trust. A trust is a legal entity that is created through a two-step process. Step one, you will meet together with an attorney. They will ask questions. They will determine what your wishes are. And then the lawyer will put your wishes and your dreams into legalese so that all of your desires, wishes, distributions are carried out. And then the second step is that we have to transfer property into the name of the trust so that the trust now owns the property that used to be in your name as an individual. The people that are involved with the trust are as follows. There's the creator of the trust, that's you. You're the one that comes into the office. You tell us what you want done. You set the terms. You identify what you want done, who gets it, when, and so forth. And then we also have to identify a manager that can manage the property that's created or transferred over to the trust. That manager, while you're alive, is also you. So you, while you're alive, you're creating the trust. You're also the manager. And you can invest the assets. You can manage all the assets. You can do whatever you want with your property. And then upon your demise, or if you become incapacitated, then there will be a successor manager that will be appointed. And their responsibility would be to follow whatever the terms of the trust are that you created while you were alive and you created the document. And there's also a beneficiary that will benefit from all of the benefits that are in the trust. For example, while you're alive, you're the creator, you're the manager, and you're the beneficiary. So you do not lose control of any of your property. And then upon your death, though, again, the successor manager will step in, and then they will transfer the property to your beneficiaries as you have identified, as you have dictated that you want done, totally under your control. The trust is basically a contract between the settlor and trustee. You, creator, and the manager trustee. You set the contract terms. You identify what you want done with your property. You identify who gets what when. The manager trustee's job is to carry out your wishes. But in order to carry out your wishes, the trust has to own the property, and therefore we have to transfer property into the name of the trust. And that transfer property is generally called funding. And we retitle, for example, real estate, like the title of your home, into the name of the trust. We transfer stocks and bonds. We transfer brokerage accounts that are non-IRA. We transfer bank accounts. And basically, we transfer the majority of assets that can be transferred to the trust, which are generally most everything except items like IRAs, 401ks, pension plans, items that you have never paid tax on. Now, what are the benefits of having a trust? Number one, you will avoid all the delays of probate and the expenses of probate. Number two, the trust is totally private. It does not have to be filed. It does not have to be put into the court system. Nobody, except whomever you have identified that you want to know, knows what's in your trust and what's in your estate. It allows for better tax planning. It can avoid court-supervised guardianships and conservatorships. And more important, it will ensure your wishes, not the court's wishes, are carried out. So what do you think is best for you? A will or a trust? I think the trust is the answer. And that is what the majority of the estate plans are today, a trust. Now, for those of you who have a trust, what I want to cover now is some of the most common mistakes that we have seen over the years. And if I point out these mistakes that people have made, maybe I can give you guidance as to what mistakes you can avoid or how to avoid them. Number one is, when I ask the question, what kind of trust you have, a lot of you will answer, well, I have a revocable trust. Well, then I ask, what kind of revocable trust? Because believe me, there's about 15, 20 different variations of a trust. QTIP, QDOT, AB, AA, BC, disclaimer, all types of different kinds of trust. And therefore, it is critical that you have the right kind of trust to begin with. If you go to a law firm that doesn't understand estate planning or doesn't do that as a specialty, they may create a trust for you, but it may be the wrong type of trust. We're living longer. The trust has to address the incapacity issues. The trust has to have planning in case you have to avail yourself of Medi-Cal benefits in California. Your trust has to have protected provisions that would benefit your family. Protections from spouse remarriage, undue influences, creditor and divorce protection, preventing disgruntled beneficiaries from attacking the trust without any due cause whatsoever. That's done by providing a no contest clause, and also helping people who may not be able to control their inheritance from substance abuse and, again, undue influence. If your trust does not have these protections, it is not working as hard as it should. It is not protecting you the way it can protect you. Other issues. A lot of you will create your own document. And, well, yes, today we have software, LegalZoom, all kinds of other companies that are offering do-it-yourself. But think about it. the templates that you find in these programs are general of nature. They may say that they're California law, but they don't have the content that you would have if you had a law firm that specializes in this area of the law would have for you. It just does not work. It's not there. In addition, if you create your own trust, you will not have the benefit of having a law firm behind you in case issues come up with your legal document. And also, we do not encourage you to write on your original document because you will simply create an ambiguity. In other words, who crossed out the $100,000 gift to my child? It's going to create ambiguities. It might only lead to court contests when you die. The same thing, trying to change the trust on your own. A trust has to be amended with the same formality as the original trust was created. We have to follow the legal process identified in the trust law. And the other issue is that you created a plan maybe 10 or 15 years ago, and there's been significant life changes, like maybe children have died, or maybe grandchildren have been born, or maybe there have been remarriages. So as life events change, you have the ability to keep your trust updated. And that's one of the beauties of this type of document, because it is active while you're alive, and you have the ability to keep it updated with changes that occur in your life. Another one, which is absolutely critical, is that people do not change ownership of the assets to the name of the trust. And therefore, pay attention to this. If the trust does not own the property, it will not avoid probate. A common fallacy is people create a trust and they never retitle the assets in the trust, and then they die and they have property outside the trust, and those assets can go through the court process called probate. Do not make this common mistake. Other issues: wrong property description, wrong signing date, you incorrectly titled assets that you thought were correctly titled in the name of your trust, or leaving property that's encumbered with a debt to somebody that cannot service the debt. For example, you leave a home to a child who doesn't have a job, and there's a mortgage on it, and the kid cannot pay for the monthly payments on the mortgage. What do you think the bank is going to do? Also, another common mistake is a lot of times people will put on children on title with them as joint tenants while you're still alive. The issues that occur there is if that individual who's on title with you, for example, gets involved in an auto accident, they can get sued, and then they can sue them and take your house away. So there's a lot of reasons why you do not want to put on an individual as a joint tenant on your property while you're still alive. Managers. If you name co-managers, you have to make sure that they agree 100%. You have to have the correct distribution language. I read a trust the other day. The distribution language was, I leave everything to my heirs. Well, who are the heirs? The distribution language has to be very specific. You have to make sure that you have updated your successor trustees with the right people. Again, protect against beneficiaries from fighting. Leaving inheritance outright to minors, that is not necessarily the best way to do it, because then they will be unable to inherit because they're minors, and then you may wind up with guardianship petitions fighting over who's going to manage the property for the minor. But if you leave the money for a minor inside of your trust, you can avoid guardianship petitions and make it simple because you can identify how you want the money distributed to the minors. Another incorrect fallacy, or is a fallacy, is the fact that you have an IRA that is leaving the IRA to Sally, but then you write in your trust that you want the IRA to go to Johnny, not Sally, and you mistakenly believe that because you wrote in your trust that the IRA is going to go to somebody else besides the person who is named in the beneficiary form, that trust document is going to override the beneficiary designation, and it does not. Complexity of an estate plan is generally when there are second marriages. Your kids, of course, are the troublemakers. My kids, angels, our kids, perfect angels. Look, when there are second marriages, several sets of children, stepdads, stepmoms, a lot of issues come up that are different than in a normal estate plan. And planning can allow you then to provide for them equally or differently, depending on the needs or merit of the children. And you can protect both sets of children from unequal distributions simply by having a good estate plan for blended families. Again, the trust is a vehicle that can provide unbelievable protection. Creditor protection, issues dealing with subsequent marriages, undue influences. You can protect beneficiaries, again, from maybe your daughter is married to somebody who's just waiting for you to die so they can inherit your millions. Well, you can put in protection so that divorce and creditor protection could be listed in your legal documents. Maybe you have children who are subject to substance abuse. We can protect them. What if you have disabled beneficiaries? We can protect them. What if you have minor children? They could be protected. What if you have children with special needs? The trust is a fantastic document. And the beauty of that document is that depending on the knowledge and experience of the law firm, they can put in all of these protections for you. A trust is not solely for avoiding probate. It is a legal document that can provide you with unlimited protection while you're alive, and again, transferring property at death without probate. Prince, this guy, fantastic talent, never created an estate plan. He did not have a trust or a will. He had over $300 million in his estate. His greedy heirs are still fighting over the $300 million estate. Guess who the primary beneficiary of that estate is? The IRS. They're going to get as much as $150 million in taxes. All of this could have been avoided. Paul Walker, he had a trust. What was that problem? He did not put all the assets in the name of his trust, and he did not update his documents with life changes. He, for example, had not included his daughter in the trust and his $25 million estate, because he had not funded the trust completely, had to go through probate. And of course, he did not expect to die young. So these are issues that happen, and these are things that can be totally prevented by proper planning. Now I'm going to give you some legal updates. In the federal estate tax world, the federal estate tax is basically a tax that is levied by the federal government on transfers that are made at the time of death. These transfers that occur at death are taxed by the federal government. And there are some exceptions that if you transfer, for example, an estate to a surviving spouse or to a charity, then there would not be any federal estate tax. And in addition to that, all of us today during the year 2022, all of us have the ability to transfer exempt from any federal estate tax, 12,060,000. So unless you have a super large estate at this time with the current laws, you do not have to worry about a federal estate tax. So again, the federal estate tax is the tax that applies to transfers that are made at death. The advantage of a married couple, is the following. Each spouse, husband or wife, they have the 12,060,000 amount that's exempt from federal estate tax. But if the husband, for example, dies and he's never used his exempt amount of the 12,060,000, he can then transfer the unused amount to the surviving spouse. And therefore now the surviving spouse could have up to 24 million plus of money that she could transfer tax-free. Again, for married couples, you can transfer the unused amount of your exempt to the surviving spouse and double the amount of the money that the surviving spouse can have. In this example, the person could have up to 24 million that could be transferred federal estate tax-free. But I want to caution you, this law is set to end in 2025. And when we wake up in 2026, the amount that could be exempt is going to be cut in half. So let's assume that 2026 arrives and the amount that you can exempt is 12 million per person. It will be cut down to 6 million. And there's a possibility that it could be cut down to even more. Now, recently, all of us who have real estate have experienced an increase in property values. I want you to think about the possibility of your estate growing to the point that perhaps getting close to a 4.5, maybe $5 million estate value. And then if you can only transfer, because of the amount has been cut in half, 6 million of federal estate tax exempt property, and now your estate is growing close to that number, there's a possibility that before you die, your estate may be subject to federal estate tax. And the federal estate tax is generally about 40%. So I think all of you have an estate that appears to be growing, and you think you might be closing in on a $4.5, $5 million estate. I think you should talk to us about some advanced planning in order to avoid any federal estate theft that could just completely destroy your estate that you worked hard for all your life. Let's move on to gift tax. If you give property away during life, there's the gift tax. Currently, there's one code section that basically says that you can give up to $16,000 per person annually, and you never have to pay any gift tax. So you can wake up every morning, for example, and pay $16,000 to everybody in town, and you would never have to pay any gift tax because $16,000 per person per year is excluded. Then in addition to that, the 12,060,000 that I talked about that exists as an exempt amount at death, that same number exists during your lifetime. Because what happens is that you have one coupon worth 12,060,000, and that coupon, you can use it during life or at death. So if during lifetime you give away $10 million, then at your death, you only have 2,060,000 to transfer death with no tax. So the gift tax exists during your lifetime. So you could, this Christmas, give away millions to your child without paying any gift tax. It is interesting that a lot of you have never paid attention to what happened when we voted for the elimination of Prop 13 and voted in Prop 19 that affected properties in California. Prop 13, for those of you who existed during the Howard Jarvis days, the purpose of Proposition 13 was to keep property taxes low, because at the time, what was happening is that the property values were increasing every year, and California then could reassess your home every year based on the new value of your home, and your property taxes were increasing to the point that people could not afford to pay the taxes and were losing the property. So Prop 13 was implemented to put a cap on the amount of taxes that the state of California could levy against your property. So after Prop 13 was implemented, the property taxes were kept low. And again, the maximum that they could ever increase to still is was 2%. So under Prop 13, the only way that the state of California could reassess your property was when there was a change of ownership. A change of ownership would be if you sell the property, if you give it away, or you inherit the property, and the property could be reassessed unless there was some sort of an exclusion. Also, under Prop 13, parents could leave their primary home at any value to your children without any reassessment. You paid $200,000 for a home. Maybe the taxes were $500 a year. Now that home is worth $5 million. You transferred it to your child under Prop 13. They would inherit the house, and it would never be reassessed. And in addition to transferring the home without any reassessment of any value, each parent could leave up to $1 million in assessed value of other real estate to the children without reassessment. It was a win-win situation. So what happened? Prop 19 came in and they absolutely restricted the parent, child, grandparent, grandchild exclusion. And currently under Prop 19 is parents can still transfer the primary home. However, there is the requirement that the child must occupy the home as their primary residence. And there's also a limitation on the amount that can be eliminated from reassessment. So now there's a tremendous restriction on the transfer of the primary home to a child or from a grandparent to a grandchild. It is important that you see us so that we can add verbiage, language to your trust document so that a child could take advantage of this remaining exclusion so that they can keep the old property tax value of your home when they inherit your home. Again, Prop 19 has completely changed the way parents can transfer property to children. California, you can think of it as the California death tax. Laws were passed allowing parent to children and grandchildren and grandparent to grandchildren. And Prop 19 took all of that away. And now there'll be a tax bill along with the sympathy card. This is really important. And just as an aside is that for the November 2022 election, we tried to get a petition on the ballot to overturn the Prop 19 bad parts, and we were unable to collect all of the necessary signatures. And the reason was that people did not really understand what Prop 19 was. One more, the Secure Act. What is that? The Secure Act is really IRS rules that have gone into effect that affect how IRAs are inherited. Retirement plans are a huge part of your estate. and the future inheritance to your children. Most retirement plans, IRAs, 401ks, 403bs, and those things are transferred by beneficiary designations to specific individuals. And those transfers occur without any type of guidance or without any type of tax planning. Secure Act passed, and a couple of good parts. Now, you don't have to take out any required minimum distributions from your IRA 401ks until you're age 72. Remember, it used to be 70 and a half. Also, you can continue to contribute to your IRA if you're working. There's no more limitation that you cannot transfer money, earned income to your IRA like it was before. It was capped at 70 and a half. It also allows penalty-free withdrawals of $5,000 by each parent in the year of birth or adoption of a child. And it also permitted some penalty-free withdrawals from a 529 plan. Here comes the bad part. Before Secure Act, if a child inherited an IRA, I'll say an adult child, they could take out small amount of money as required distributions over their lifetime. So if you left an IRA to a 40-year-old child, that child could possibly have 50 years to take money out of the IRA, therefore minimizing the tax effect of the money that's taken out. Now, the Secure Act requires you to take out all of the inherited balances of the IRA within 10 years of the account owner's death. And if you do not take the money out within the 10 years, there's a 50% penalty on the amount that you did not took. There's a 50% penalty on the amount that you did not take out within the 10 years. There's several exceptions to the rule: spouses, disabled children, chronically ill, minor child of an account owner, and somebody who's less than 10 years younger than the account owner. These are super complex rules for IRA distributions, and it's critical that you understand them. Our trusts now have updated language to deal with the Secure Act, because if you fail to accommodate the distributions within the 10-year rule, then there can be severe penalties. Long-term care, critical part of an estate plan. The main concern as we get older is not dying, because what can we do about that? Nothing. It's becoming ill, losing our memory, being a burden to our family, outliving our money. We talked about that a little bit. So these are the main health concerns that we have. And as we get older, we're going to be needing help and care. So when you look at this chart, look how expensive the cost of care in California has gotten. Home health aides, over $6,000 a month. Somebody to help you at home, over $6,000 a month. Assisted living facilities, over $5,000 a month. Semi-private room in a nursing home, $9,700 a month. Private nursing home expenses, $12,000 a month. And look at the projected cost by 2030. Cost of care in California are increasing. Cost of care is an issue, major issue, because we're living longer, and then we are then subject to incapacity. So if an illness hits you and you are then subjected to long-term care. Long-term care can be care at home, it can be care in a nursing home. How are you going to pay for these tremendous expenses that may now be falling on your estate? Are you going to do it from your monthly income? Do you have enough savings? Are you going to sell your home? Are you going to ask your family to help you? Did you buy long-term care insurance? Or are you going to then avail yourself of the government programs that are available under the Medi-Cal rules in California? Medicare and Medi-Cal are two different insurance programs. Medicare is the kind of program that we get when we're 65 and older that generally covers hospitalization, medical visits, prescriptions. Medi-Cal is different than Medicare. Medi-Cal is the program that exists for covering payment for long-term care issues. I want to bring to your attention a very important change that occurred in Medi-Cal. Medi-Cal, prior to July 1 of this year, required an individual who was applying for Medi-Cal to be able to have no more than $2,000 of exempt assets, of non-exempt assets. And now the new law allows them to have $130,000. And if they live in a home with a living spouse, then the amount that they can keep, which is basically a non-exempt amount, is $195,000. So the new changes have made it somewhat easier to qualify for Medi-Cal. And when we reach the year 2024, it's possible that there would not be any limitation on the amount of assets that you have. So the question is, what do you think you should do now to plan in case you wind up dealing with incapacity issues? I submit to you that you should consider establishing at least a very basic Medi-Cal plan so that you can avoid depleting your estate if something like this happens to your family. We can provide language in our trust documents that would authorize somebody to enter into advanced planning so that they can avail yourself of whatever the laws are at that time that you need to apply for Medi-Cal to qualify for Medi-Cal. And then there's another important point. If the state of California under Medi-Cal, for example, provides, let's say, $200,000 of benefits to the person who applied for Medi-Cal, upon the death of an individual, there are laws in the state of California that say that they can recover for the amount that they spent for you. They can come back and recover $200,000. Well, that doesn't sound very good. Well, new changes to the law now prohibit the state of California from recovering from your estate. They can only recover from a probate estate. Let me say it again. California can now only recover from assets that are part of probate. They cannot recover from assets that are not probate. What assets are not probate? Your trust. This is a very important reason why you should have a trust. You should have a trust so you can have the proper language in the trust document that would give authorization to somebody to enter into advanced planning in case you need to have payment by the government for long-term care, and also for protection from any payback provisions in case you wind up getting on Medi-Cal. An estate plan requires more than a trust. It requires a durable power of attorney so that you can have somebody the authority to act on your behalf on financial decisions. They can sign your name on various aspects when you're unable to do so. Advanced Healthcare Directive in California. This would give authority to someone to act on your behalf to make all the healthcare decisions that you may not be able to make them. And you need to have these documents because they're critical documents to have. And you also have to make sure that you provided these documents not only to your doctor, but to your hospital, but also to your family members that you have named as agents under these various documents. There's a companion document called a pour-over will. Yes, we create a will in addition to a trust because this is kind of like a backup. It's a document will that accompanies your trust is to transfer any assets that you left outside the trust at your death and transfer them back into the trust so they can be distributed for the terms of the trust, but it has to go through probate because it's a will. But it is a safety net that we put into the estate plans. letter of instruction. This is a fantastic document in the sense that here you can identify how you want your remains disposed of, who to notify in case of your death, or maybe who not to notify, where are your documents going to be located, how will you be distributing your personal effects, who gets the painting, for example, who gets the lawnmower. This is a document that you write in your own handwriting. It's instructions to your successor managers. It is definitely a fantastic document because it's instructions telling your family what you need to be done when something happens to you. If there's anybody out there with a special needs child, I need you to be aware that you cannot leave an inheritance to a special needs child outright because they will be removed from any benefits that the government has for them, because governmental benefits are based generally on an amount of income or assets that the person who is a special needs child can have, and therefore there are limitations as to how much money they can have, and therefore if you leave an inheritance to a special needs child, they will then have over the amount that they're able to keep, and they will be removed from any benefits. And therefore, the way that you leave an inheritance to a child is you leave it through a special needs trust. If you have pets, if you're a pet lover, you have to think about them. A lot of times we do not think about these loving little creatures that are part of our family. Something happens to you, who's going to care for these pets? Who's going to provide for them? What provisions have you identified for their care? You can have a pet trust in your own trust. California actually has code sections that identify and permit the creation of a pet trust. If we make it simple for you, we can simply add like a half a page of a pet trust in your current estate plan, and then that can give instructions as to how you want your pets taken care of if something happens to you. Not death, also remember incapacity issues. When somebody dies, look, there are legal requirements that have to be met, reporting requirements, trust plan requirements, financial requirements. It is extremely emotional grieving period for families at this time. Gentlemen, our spouses are going to grieve for about 5 minutes. This is the advice that I'd like to give all of you. You're both alive, you're both well. Enjoy what you have, make living memories, live your life now, because when something happens to one of you, your wife or your husband is going to wish you were still there to live these memories that you're not creating without them. So I really encourage you to think about your estate plan and really live today and make the memories that can last a lifetime for you. We're here to help you. Our job is to help you navigate through whatever issues you may have with your estate plan. And we'd like to hear from you. We have on the slide there how you can contact us. There's a telephone number. We have a website. And we're here to help you. That's really what I can tell you. And I want to thank everybody for joining us. And now I think I want to look and see if there's any questions that I need to be answered. So I will go through, see what questions. I don't see any questions at this time. And so therefore, I'm going to say goodbye. And I hope I see you in the office. And I hope that we see you soon to plan, not necessarily to do it as any type of administration. Thank you very much for joining us.